So we're going to be covering real estate deeds today. The title of this class is Real Estate Deeds for You, Good Deeds Done Daily, and learn the ins and outs of deeds in this course. We're going to be covering real estate title transfers, interspousal transfers, transfer of property in and out of a trust, business entities at death, and we have a more detailed table of contents here. This is an educational program about real estate deeds. Introduction, title versus deed. Title is how you hold the title, tenants in common, joint tenancy, community property, and the deed itself indicates how you came about getting that title. You figure the title is existing ownership, kind of like pink slip on a car, and a deed is kind of a motion document that gets recorded and then stops moving, and that's how you're holding it as title investing or synonymous. So we're going to cover the components, Disneyland world of deeds. It's a small world after all. We're going to cover the form, walk through the different square inches of the form. We're going to cover government patent deeds, warranty deeds, grant deeds, how you get out of government tax codes, quitclaim deeds, gift, life transfers, transfers on death, parent-child exclusion, notice of death of real property owner, preliminary change of ownership report, granting of a conservation easement, correcting a deed, out-of-state deeds, transfer disclosure statements, land contracts of sale, option to buy contract, purchase subject to existing loans. And what happened to my page here? Okay, interspousal between husband and wife, community property with right of survivorship, transfer on death deeds, and joint tenancy. So we'll continue on here about the deeds class. Let's go back to page 2. Tenants in common, a deed after divorce, transfers of property to and from your living trust to transfer deed, trust transfer deed, pour over will, 3 children separate trust, transfer to a business entity, to LLC, corp partnership, affidavits of death after one of the co-tenants dies or some other party related to a deed, death of a tenant common, death of a trustee or change of trustee, death of joint tenant, dissolution of a corp. We have death of community property owner, spousal property petition, death of community property owner with right of survivorship, death of transfer on death deed, real property owner, death of real property owner, supportive equalization form, loan-related deeds, deed of trust, promissory note, or also called a mortgage, promissory note secured by deed of trust, carryback mortgage, substitution of trustee on a deed of trust, full reconveyance, notice of default, trustee sale, self-canceling installment note, government property tax sale deed, sale and probate, distribution in kind, title transfer, voidability on transfer, and a footnote from above. The most common and important deeds and forms are the grant deed, the quitclaim deed, the trust transfer deed, and the preliminary change of ownership report. So those are the most important in this class. And we have an appendix that has blank forms in it for your use. Introduction to deeds. Welcome to the fascinating world of real estate deeds. In this comprehensive course, we will delve into the essential aspects of property ownership, crucial role that deeds play in real estate transactions. Whether you are a first-time homebuyer, seasoned investor, simply curious about the intricacies of property law, this course will provide you with a solid foundation to navigate complexities of real estate deeds confidently. We will explore various types of deeds, such as warranty deeds, quitclaim deeds, grant deeds, and more, understanding their unique features and when to use them, little buggers. Join us as we demystify the language of real estate documents, decipher legal terminology, and gain insights into the importance of clear and valid deeds in protecting your property rights. By the end of the class, you will be equipped with the knowledge to make informed decisions and approach real estate transactions with confidence. Title and deeds. Title, both related to property ownership, but different aspects of real estate transaction. What is title? Title refers to the legal right to own the property and use the property. It represents the ownership interest of the property and encompasses all rights associated with that ownership. A clear title means there's no claims or encumbrances that would impede the property's transfer. Then what is a deed? A deed is a piece of paper that was recorded. A deed is a legal document that serves as evidence of the transfer of ownership from one party to another. It is a written instrument that conveys the title of the property from the seller, grantor, the buyer, grantee. The deed includes a description of the property, names of the parties involved, and the terms of the transfer. In summary, title represents ownership rights, while a deed is the document that conveys or transfers those rights from one person to another person. So let's go through some of the transfer deeds. First one is a patent deed. Land patent. This came about, Abraham Lincoln signed the Homestead Act of 1862, and it allowed the government to give people land. On January 1, 1863, Daniel Freeman was the first to claim under the act. It gave citizens and future citizens up to 160 acres of public land, provided they improve it, pay a small percentage registration fee, and the government granted more than 270 million acres of the land while this law was in effect. What is a land patent deed? The federal government used a patent deed as a legal instrument to transfer ownership of real estate to an individual. A patent deed is a formal document issued by the government, typically after the land has been granted through the process like homesteading or public land sales. It serves as conclusive evidence of the individual's right to the property, confirming the government has relinquished its claims to the land and transferred it to the person named in the deed. This essential legal document assures a clear and unambiguous transfer of real estate ownership, providing security and stability for the new land owner. This is an example of a 160-acre land patent deed. You'll notice it doesn't look like it was made anytime recently. This is another transfer of ownership to an individual. Warranty deeds. When you go on the internet, you always hear about warranty deed, warranty deed. Most all of the ads are from out of state. So a warranty deed is a legal document used in real estate transactions to transfer ownership of property from one owner to another in many states, but not California. It provides a warranty, guarantee that the seller, grantor, holds clear and undisputed title of the property and has the right to sell it. By executing a warranty deed, the seller pledges to defend the buyer against any potential legal claims, translated litigation, or disputes arising from the property ownership history. Like a quitclaim, which offers no warranty. and only transfers the seller's interest in a property. A warranty deed ensures a higher level of protection for the buyer. It includes a statement of warranty promising that the title is free from defects and encumbrances, except those explicitly stated in the deed. A warranty deed is a crucial legal instrument in real estate transactions to guarantee the buyer's peace of mind and safeguard their investment in the property, not in California. It is rarely used in California because title insurance makes warranty deeds irrelevant. In California, go look at the deed called a grant deed. Okay, what's a grant deed? Okay, so this is a sample form of a warranty deed after I said they're not that good, but here's one example of a warranty deed that could be used, I wouldn't, in California. And it needs a notary someplace. This is a faulty notary because a notary has to have wording up above. There's a square box that we'll see. Grant deeds. What is it? It's a legal document used in real estate transactions to transfer ownership of a property from one owner, one party to another. It is commonly used in many states in the United States. In a grant deed, a seller or grantor confirms that they have the legal right to sell the property and conveys their interest in the property to the buyer, also called grantee. Unlike a warranty deed, a grantee provides fewer warranties, typically limited to two main guarantees. The guarantor has not previously transferred the property to anybody else, and that the property is free from undisclosed encumbrances created by the grantor. In essence, a grantee assures or guarantees that the grantor has the authority to sell the property, and that there are no hidden liens or claims against the property except those explicitly disclosed in the deed. While it offers fewer protections than a warranty deed, grantee is still a significant legal instrument used to establish clear ownership rights during real estate transactions. It is the most common deed for real estate purchases in the state of California. Now, let's dissect this deed document. So, this form is 8.5 by 11 page, and we'll cover the top and bottom part. And it starts out in the upper left. We've got the name who is asking for it, title company, perhaps an LDA. Then where do you want it to go after it's been recorded? To the new buyer, to the attorney creating the deed. Then we have this next box is kind of buried. Is you have to leave this blank 3-inch area so that the county recorder can put their fancy stamp on there and the document number when it was recorded. You need to put the assessor's parcel number. So you find that on the existing deed. You cannot create a deed unless you have the last recorded deed showing a lot of the information that we're going to be needing. Assessor parcel number is one of them. So are you exempt from documentary transfer tax? If not, put a dollar amount. If you are, we're going to cover the codes later, where you can get exemption, like to and from a trust or to a homeowner, the principal residence, and a place for a signature that you're declaring that you have the right to exclude or pay the tax. This is another tax here, the government code 27388. The I think it's called Homes and Jobs Act. If you're not having it as a principal residence, they'll tax you $75 for recording, up to a maximum of $225. Now, we get into the granting section. For valuable consideration, or which is hereby acknowledged, the grantor person giving up their rights and the form of title that they have now, and they grant it to new owners, including the form of title that they want: tenants in common, joint community property, right of survivorship, joint tenants. And you just have to make it really clear. You have to have the grantor in order to not cause problems in the chain of title over many, many transfers, that the names going out, granting out, match. You know, whether it's full middle initial spelled out or whatever it is, match it going in a type of title. And then do what the buyers want on the grantee. So these are some examples that I mentioned. It could be community property, right of survivorship, or true trust. Following property in a city and county of county. And that's important because the assessor parcel number up here relates to a specific county for that property. And here they call enter the legal description as written on the most recent deed or photocopy. Attach it as Exhibit A or write it here. They always call it the legal description, but what it really is a surveyor's description of they measured out the property, and usually in a subdivision map act, the survey is recorded, and that's where the legal description comes from, and then it's carried forward from that time. I've worked on property where they've split lots and different things, and takes a long time for the correct legal description to get showing on the county records. So this is the declarant, that's the grantor. And if there's two people, we have, or a current owner, second owner, then they both have to sign it. And then the next page will be a notary acknowledging that and a legal description. But we're going to look at something else. Okay, so you locate the current deed. You can get them, go to the county office, do a search of grantor, grantee index. We have private databases we pay for to get deeds. Some counties allow you to buy them directly from the deed after you do they have a grantor grantee index. You can search by year ranges and find out what a document was for that person's name, and then get a printout of the prior deed. So what kind of deed do I need? This anti-world chart says if it's a gift of property, give them a grant. If it's a sale of property, give them a grant. Move property in or out of a trust, and grant deed. Not required by law. Update after a name change, do it as a grant deed. So these are common reasons to use a grant deed, although it's not required by law. I tend to default towards grant deeds. You're giving up rights to a property. Here's a quick claim. Whatever I got, you did. Claim, divorce transfer, perhaps, waive claim of other spouse's separate property, potential inheritance rights, and transfers between spouses and registered domestic partners, interspousal deed. These are just names, and most of the time, the difference in a deed is just the big letters at the top of the document. So it'll say, "Oh, California grant deed." Okay, fine. Or you want it, you just change it, and then your wording that follows will match that. These documents, deeds, are not government issued or required. So they're free form, that you learn how to write it out and then you make it match. Here's one of a couple charts that might help someone in their selection of what type of deed they would like to have. So choose married people, community property right of survivorship, who can sell, what happens if you die. And it's a helpful chart to go down step by step. And if you're working with another party trying to help them do a deed, you can give them this form so they can make their own decision. This is another chart on how to do deeds. I think Jim Wilroy for this one. It shows the different types of title designations, what is a description of it, and how does it transfer on death. Revenue and Taxation Code disclosures. As I mentioned earlier, the in the upper right, we have tax codes that you have to use. If you leave them out, you get to pay the tax because the county's not going to remind you, gee, you could get out of a $250 tax if you just wrote RNTC code 11930 right here. But you have to know it. You have to assert your rights. So there are several charts available to find out what tax you might be excluding the documentary transfer tax. And these are all California Revenue and Taxation Code sections. That's also where they get the California income tax sections is RMTC. So we have an example. If you gave somebody a gift, you would say, I'm exempt from the documentary transfer tax because of 11911. And so we've listed a lot of them. You have to look at your circumstances. Here's one exempt, 11927 for divorce. Transferring in and out of a trust is common, the 11930. So there's a lot of them, and this is a little easier form to read because of the formatting. I have another example that is real thorough, but it doesn't have the same format. And I've included a chart here for documentary transfer tax. And most of the time, the California Revenue and Taxation Code starts out at 55 cents per $500 of value transfer, assuming it's a purchase. They could say it easier at $1.10 per thousand of transfer value. And then I'll show you one later. There are certain cities and counties, Alameda's one, Oakland's horrible, where they charge you a huge amount of tax just to transfer title. It's obscene, and it's not uncommon for me to see $10,000, $11,000 just because the city has jacked up their tax on transfers of real property. But fortunately, most cities are not that greedy, but a lot of them in Alameda County are, some in San Mateo County. And I just included a chart here so you could calculate it if you have it due. Quitclaim deeds. Another way to say a quitclaim deed, whatever I got, you get. It's a legal document used to transfer ownership or interest in property from one person to another. Unlike a warranty deed or grant deed, quitclaim deed does not provide any warranties or guarantees about the property's title, quality of title, or ownership. Instead, it simply conveys whatever the hell interest the grantor has in the property to the grantee without promising diddly squat that there's clear title or free encumbrances. So my example of a quitclaim deed is it's not illegal or fraudulent or breach of contract if I gave you a deed quit claiming all my rights and ownership interest in the Golden Gate Bridge. And it was ready and you notarized and recorded. Whatever ownership I had in that bridge, you get it. It just so happens I don't have any ownership interest. So what do you get? Nothing. Not diddly squat. So there's no warranties of type. This type of deed is often used for the transfer of property to family members or in cases of divorce or gifts. It is also commonly used to correct minor title issues, remove someone from the property title. Because a quitclaim deed offers no warranties, the grantee assumes any risk associated with the potential title defects, known or unknown, claims on the property. It is essential for both parties involved in a quitclaim deed transaction to fully understand the implications and consult with a real estate attorney or professional to ensure their interests are protected. Gift deed. Another flavor of deed. The legal document used to transfer ownership of property from one person to another, donor to donor, to a recipient or donee as a gift without any monetary value exchanging pause. It's a voluntary transfer of property rights where the donor gives up all claims to the property and the donee becomes the absolute owner. The gift can include real estate, personal belongings, or other assets. But if it's a deed, it's going to be real property. A deed typically includes the details of the donor and the donee, description of the gifted property, intent of the transfer of the gift, and any terms and conditions, if applicable, once the gift deed is executed and registered or recorded with the proper authority. The donee gains full legal ownership to the property. Gift deeds are often used to transfer property within family members for charitable purposes as a means of estate planning to distribute assets during the donor's lifetime rather than through a will. Now, we have an example of a California gift deed, and there's some defects that I want you to see right off that we've already talked about, and one of them was that you have to have all those code sections in order to get out of the different kinds of taxes. So you've got to tell the recorder what the revenue and taxation code section is, and to get out of the revenue and taxation code, and then the government code exemption, you need to tell them whether it's going to be an owner-occupant property. And this one includes other extraneous things like intellectual property, which is normally not included on a deed, so it's a little unusual. And another notary with faulty notary wording. And this is much shorter wording. Normally we want to have a little bit more detail than that. They're standard notary statements. Life estates. What is a life estate? It is a legal arrangements in real estate grants one person known as the life tenant to occupy the property and use the property for the duration of their lifetime. After the life tenant croaks or dies, the property ownership automatically passes to the other person known as the remainderman or remainder woman. The life tenant remains the rights and responsibilities of ownership during their lifetime, but cannot sell or transfer the property beyond their own lifetime. Life estates are commonly used in estate planning to ensure a designated individual can live in the property while still allowing the property to transfer to another beneficiary on their passing. This arrangements can be beneficial for individuals who want to provide for their spouse or loved ones without directly transferring full ownership. It is essential to understand legal implications of a life estate, and consulting with a real estate attorney can help enrich the attorney and help ensure the arrangement aligns with the individual estate planning goals. So one example of a life estate, there was an elderly woman who had cancer. She didn't have long to live. She had one son. and she put her son on as a remainderman and her as a life tenant. Then her cancer was cured and they had the life tenancy on there, and she wanted to move to a different property, and she had to have her son sign because he's a remainderman. He refused to sign, so she couldn't move. So it would have been much better had she put her property in a trust. Transfer on death deeds. It's also known as a beneficiary deed or TOD, beneficiary deed. It's a legal document that allows a property owner to designate a beneficiary who will automatically inherit the property on the death of the owner without the need to go to probate, but you still have to file some form. This deed enables seamless transfer of real estate to a named beneficiary upon the death of the property owner. While the property owner is still alive, they retain full control, ownership rights over the property. A designated beneficiary has no legal interest, can't complain or squat about anything with the property. However, when the property owner passes away, the beneficiary can claim ownership without having to go through the probate process by filing certain papers. A TOD deed offers straightforward and efficient way to transfer real estate to chosen beneficiary, avoiding the time-consuming cost of probate proceedings. It is important to follow the specific legal requirements of the state where the property is located to ensure that these validity. And there's some advantages of transfer on death deeds, TOD. One is it avoids probate. One of the primary advantages is that it helps bypass probate process, can be time-consuming, expensive, tie assets up for a significant period with TOD property transfer directly to the beneficiary on the property owner's death after filing another form. Simplicity and flexibility, setting up a TOD, relatively straightforward, setting up compared to setting up a living trust, provided simple, flexible way to transfer real property to a designated Benny or Bennies. Retains control during life. Unlike an outright gift of property, TOD allows the person to retain full control of ownership during their lifetime. They can sell, mortgage, otherwise deal with the property as they see fit and cut off their beneficiary. It's revocable. You can change it at any time, change your mind, revoke, and the beneficiary cannot say anything about it. It's cost effective. It is a bit more to create a living trust, but it's better and worth it. It avoids conservatorships. In the case the property owner becomes incapacitated, the TOD deed can help avoid the need for a conservatorship, since the ownership remains in the property owner until death. Yeah, but they can't control it if they're a question. Reduced tax implications. For federal income tax, inheriting, TOD provides a beneficiary with a stepped-up property basis, current market value, reducing capital gains. If the beneficiary decides to sell the property. Now, what's screwed up about a transfer on death deed? Lots. The laws were updated to allow people with homes, condos, 40 units or less, or multi-unit buildings with 4 units or less, using the transfer on death deed on the owner's death. And then the property would not need to go through probate. The first problem, named beneficiary dies before the property owner. The deed becomes invalid. The property can be taken, will fall into probate on the owner's death, and the transfer on death deeds do not allow naming a contingent beneficiary, like a trust document that owns the property. Secondly, if the intended beneficiary is a minor, the minor will not be able to manage or transfer the property until they reach 18 or get a conservatorship of the estate. There is no way to name a custodian or trustee on a transfer on death deed like you can on a trust instrument. If a minor is named as a beneficiary on transfer death deed, a petition to the court would need to be filed in order to make custodian of the property or a guardian of the minor till they turn 18. And most people do not think it's a good idea giving property to an 18-year-old. Thirdly, California transfer and deed deeds provide no creditor protection for the beneficiary from a would-be creditor, such as a divorcing spouse or creditor, predator, or bankruptcy trustee. These types of protections are available in properly drafted trust after the beneficiary document for the beneficiary after the death of the grantor. So if you receive a property under a transfer on debt deed, yes, you would always get the mortgage debt on the property. But what we're saying here is you get stuck with the unsecured debt of the decedent, which is somewhat like probate. And the way that this was designed was to avoid probate for those who maybe were unsophisticated, didn't want to pay, couldn't afford a trust. But it's a significant disadvantage. And oftentimes, title companies, because there's this 3-year time period, for title insurance companies would be invalidated once the deed's recorded. Title insurance companies are unwilling to issue a new policy for 3 years after the beneficiary inherits the property, which could cause all kinds of financial hardship issues. Imagine inheriting property and not be able to sell it for 3 years and having to upkeep the property and not having the resources to do so. The fifth issue here is that the one who inherits property is personally liable for the original owner's unsecured debt. That is to protect the creditors of the decedent from being shortchanged by this estate planning shortcut. There is a similar creditor problem in probate. So I looked it up, and the Social Security Administration notifies the 3 credit reporting agencies of the death of the debtor, and that tips them off that they should go after any real property and transfer on death beneficiary. Finally, it updated the 2022 law. A beneficiary on a transfer on debt deed is now required to mail a notification to the owner's debt to all heirs of the decedent and a copy of the death certificate and the transfer on debt deed. This may require the beneficiary to perform an heirs who could be problematic and cause other beneficiary suits. You have to notify the other heirs that the property transferred and you don't get any of the bequest. I could see a lot of litigation starting from this. Okay, so we have transfer on debt deed. I don't know why we have all these definitions. We have a summary of a chart. Okay, what do we have here? Okay, so this is too large. So we're going to get rid of a lot of the wording because we don't need it. I thought I was going to be able to crop that page. Let's see. There we go. All right. Consider yourself cropped, my friend. Okay, so this is a chart on transfer on death deeds, restrictions. It must be recorded within 60 days of notarization. So it outlines a lot of the problems with the property and how the details and how it works. This is an example of a transfer on death deed. It has a lot of disclosures that you don't see on other deeds. I don't like them. I don't want to use them. This is a proper notary seal with this box up here. And these are the disclaimers or the warnings that when you get a standard transfer on death deed that are normally included, they tell you all the horrible things that might happen to you for using these deeds. So, yeah, there's a problem. Another problem on transfer on death deeds. Your beneficiary dies before the grantor, then it has to go to probate. You can only own or give out equal interests to the beneficiaries. 3 beneficiaries would have to be a third, a third, a third. You could not have differing percentages. There's just so many snags and problems with these deeds. I would advise not using them at all. Record. Okay, so these are some of the instructions. Right here. Oh, another problem with these is not only do you have to have a notary, but you also have to have 2 witnesses. So this is the most restrictive document to create in estate planning. Because normally you can just get by with just a notary. But on these, you need both. So, and it must be recorded with the county recorder within 60 days of notarizing. And that's not the case with other types of transactions. So there's a lot of not so good features of the transfer on death deed. And they're really irrelevant. If you have a trust, you don't need transfer on death deed. So this is a filled out example of what the different pieces are. Follow the little bubbles on how to fill out the form. And it's got all the details that you will need. Now, why do I have another one? Let's see what this is. Oh, revocable transfer on death deed. Yeah, this is a duplicate. Don't think I need it again. So I will delete that one. Yeah, let's delete it. Oh, let's see. So bing, bing, bing. Now, this is the revocation of a transfer on death deed, which means that the grantor is still alive and they changed their mind. So it's a little bit different and a little bit more complicated to try to revoke them, but this would be a form that you could use for that purpose. Yeah, so this is an article about the transfer on death deeds and some of the problems. I just foresee these creating a lot of probates, and that's the default. You try to get out of probate, and then it fails, and then you go into probate anyway. So it's not worth the risk, in my humble opinion. Parent-child exclusion. Okay, so you transferred property from a parent to a child, either in a trust or some other method, and then the child is going to live in the property, the parent lives in the property, and so you file this form. The property tax benefit allows for transfer of real estate between parent and child without triggering reassessment of the property value for tax purposes and some limitations. In California, we have a BOE Form 19P. So the parent has to live in the property and the child has to sign a request for a homeowner's exemption, another form to file with the assessor, and you can not get assessed up to $1 million. So if the property was worth $2 million, the parent's assessed value was $200,000, and you had the parent-child exclusion. So if the property was going up to $2 million, then you have 200,000 plus the $1 million exclusion, and you would end up only getting assessed on the 800,000 above the excluded amount. To qualify, a completed application must be filed with the assessor's office for parent-child within 3 years, or before the property is sold to a third party, whichever comes first. The assessed value remains changed and so unchanged within limits, so that inheriting child gets a much less property tax. And both the parent and the child have to use it as their principal residence for this to work. And another form, like I mentioned, the homeowner's exemption form BOE 266 must be filed to tell the county that the inheritor, the beneficiary, is living in the house. The second form is required. A homeowner's exemption needs to be filed with the county assessor's office within 1 year of the date of death. To claim the exemption, the homeowner must make a one-time filing. The required form is to claim for homeowner property taxes. And what that really does is drop your property tax assessment by $7,000, which ends up saving you a whopping $55 of annual property tax. The exclusion can also apply to transfers from grandparent to grandchildren if both the grandchild's parents are deceased. This exclusion helps to keep property tax at manageable levels for the child who inherits the property in states where rapidly increasing property values, such as California, the parent-child exclusion can be a valuable benefit as it prevents significant increase in property tax that would otherwise occur due to the reassessment of the greedy county assessor. Another separate form that needs to be filed with the the county assessor is a notice of death of real property owner. It's a change of ownership is a death causing reassessment of property tax in California, and you would file a form BOE 502D as in Delta and submit it to the assessor's office, even if the property is held in a trust. This notice typically includes the decedent's name, date of their passing, legal description of the property, and contact information for the executor, personal representative, or trustee. Preliminary change of ownership report. This form needs to go with every deed that you prepare and file with the county assessor's office. And it has a bunch of questions, the purpose of which to see if the county needs to reassess the property for increased property tax purposes. Preliminary change of ownership report is a legal document required to be filed with the county assessor office, not recorded, where there's a transfer of real property ownership. This document also is known as a P-Corp or a Form POE 502K as an alpha. Must be submitted part of the process of recording every real estate deed. During a sale or transfer of property. The deed is submitted to the recorder's office without the required P-Corp will get a $20 recording fee penalty unless corrected, but most of the time they won't let you record anyway without it. By filing the P-Corp, I say file because it's not recorded, but you give it to the recorder. They transfer it to the assessor. The assessor's office can accurately update property tax records and assess any potential changes in property tax based on the new ownership. Preliminary change of ownership provides essential information about the property transfer, including the names of the parties involved, dates of transfer, type of transfer, gift, sale, inheritance, the property's value at the date of transfer. The assessor's office determine if there's a need to reassess the property and jack your property taxes through the ceiling. Here's an example of what we call the P-Corp, preliminary change of ownership report. It's got all kinds of instructional bubbles to help you fill it out accurately. So we have the name, do they live in the property, when did they move in, who do you want the property tax statements again, even though it says it on the deed, redundancy all over again. And most all of your answers are going to be no, except those few that are really applying here. So most of the time we're using transfers to and from a trust, or transfers between spouse, or transfers between parent-child. And the second page, they want to know about the transfer, assuming it's a sale, purchase, or terms of sale. And most of the time for estate planning, not a sale. Is it a single family, multi-family? What is it? What's the quality? And then the transferee, for example, transferring your trust, it'd be transfer originating as trustee. A deed of a conservation easement to a nonprofit land trust. This is a transaction to transfer property to keep it from getting built on in the future, to keep the property from being subdivided, putting condos on it and anything else. It was first developed for inheritance tax benefits. It's an arrangement. A property owner voluntarily transfers certain rights and restrictions to a nonprofit land trust organization, ensuring the property's unique features such as wildlife habitat, agricultural land, historical sites remain conserved in perpetuity. That means forever. The land trust becomes the steward of the conservation easement, responsible for enforcing the restrictions. Just try to make a subdivision out here and we'll stop you. While the property owner retains real ownership, they agree to specific limitations on future developments or uses to safeguard the designated conservation value. Even if they sell the property, the subsequent buyer is stuck with that easement. This type of deed is a powerful tool in land conservation efforts, promoting ecological sustainability, open space preservation, and the protection of valuable resources that benefit of future generations. If you want to look up a land trust in your area, I've included a link for a directory. Yes, ma'am. Okay, so this is one of a few pages of an actual California land conservation easement transfer. And you'll notice it is like a deed, even though it's an easement. And it includes all kinds of the specification, who gets it, what are they going to do. Generally, the recipients are nonprofits, and they work well. A lot of public parks and things that you can go on are conserved in this manner. And then the original owners still live there. Correcting deeds. Oops, you messed up. So what do? You show the document number where the prior deed was recorded and the date of recordation. Restate the prior bogus wording. State the new wording that corrects the prior wording. This is an example of transferring from joint tenancy to tenancy, community property right of survivorship, and then pumping it into a trust. It's kind of a double step. So you fess up, you're correcting what you messed up on. Now what's making right about it? And let's forget this ever happened. Out of state deeds. It's important to have a copy of the last prior deed to use in modeling and preparing a new deed. Each state has different laws and recording requirements. Do not assume that the way it's done in California will be of any benefit when recording an out-of-state deed. Do not attempt to prepare and record a deed in the state of Hawaii. It's convoluted, and any disputes for real estate are adjudicated by the native tribal council and not the state courts. Transfer disclosure statement, TDS. Now, this is not recorded. It's required when property is sold. Real estate brokers deal with it all the time. The seller has to disclose all kinds of things they didn't want to. The buyer has to observe and look for stuff, and the brokers are involved. I've included a sample of a transfer disclosure statement. And it's basically required by the California Civil Code. And the wording in the thing says that it's not a guarantee. Oh, this is, but what it ends up doing, if you don't disclose, people get it sued for not disclosing. And then they, call it a fraudulent transfer. So it's, we used to have a thing called caveat emptor, the buyer beware, buyer check stuff out. But now they're trying to hang the seller to disclose everything. Oh yeah, we had spiders one time, an airplane flew over, a bird pooped on our roof, all kinds of stuff that may be adverse to a new buyer. And I'm being facetious, but it has lots of stuff on it. I was looking at a property we were selling for an estate, looked out the kitchen window and saw the garage and the roof, separate garage, and the garage roof was bowed in the middle. I mean, not straight across, but really bowed. So I mentioned to the broker that clearly has to be disclosed, that the separate garage is likely needs work. California Association of Realtors got involved in getting their transfer disclosure statement, in addition to deceptive activity on Proposition 19. And this disclosure is a common one that is used the brokers all use these documents. Okay. So let's get rid of this lousy last page. Okay, what do we have now? Seller property. I mean, it's just the disclosures never stop. In the last 8 to 10 years, the amount of disclosures that the state wants on real property transactions is, let's just say, phenomenal. It just keeps going and going. So, and then they got disclosures, and they got addendums, and then addendums to the addendums, and then tell the buyer you got to look at stuff. It's amazing. Retrofitting, and there's just a lot of disclosure. These are not deeds, but they are forms and disclosures that go into deeds and can affect the quality. A land contract is the way to buy property without involving a bank or third party. The seller finances and pays for the installments, and title remains in the name of the seller until the loan is paid off. So this happens when the real estate market becomes difficult to sell in, and sometimes they're used in no money down purchases. I've used them. You buy the property and the seller carries back the mortgage on their equity, and they're going to hold the title. I would put it escrow. And then when you pay off the seller's loan, any existing liens on the property when you bought it, then the seller would transfer the actual title to you. So in the interim, you're an equitable owner. And then after you pay off the carryback loan, then you're an actual owner. So this transaction is also known as a contract for deed, land installment contract. It's a way of financing. The sellers can put whatever terms they want in the carryback loan, subject to the usury laws and maximum interest. But it's a technique, and it's not really a deed when it's entered into. It's a contract. They call it a chosen action, but it ties up real property. They record them, and so it becomes a lien, not a lien, but a disclosure on property title, so that the seller can't sell it to someone else. But in fact, it's very much like a deed with restrictions. An option to buy contract, options in real estate, known as an option to buy, purchase, sell, agreements, real property purchases are contracts that grant a buyer or investor the right to purchase real property from a seller. Typically, the seller offers an option to buy with a limited period. The option contract in real estate ensures that the buyer exclusive rights to purchase. In addition to exclusivity, the buyer is under no obligation to follow through on the purchase. The seller is also not required to reserve the property indefinitely. There's time limits. Once the time limit expires, buyers lose the right to purchase, and sellers can offer the property to other buyers. So let's say you were selling a property and it was $1 million, and well, somebody had a property worth $1 million, and you decided to put a crazy option in on it. You were going to give it to your daughter, and then you also give her the property, but before that you record an option that you can buy the property back for $10 if she tries to sell it. So you can put strings attached in other contracts or ownership rights that are an option. It's frequently used by developers. They don't put up any of their own money, and they buy a property subject to an option. When they get all the terms and the zoning taken care of, then they continue on with the purchase. It is recorded. It becomes public record, and it's an effective way to, tie the shoelaces of the seller so that the buyer still can do what the option says. Subject to, this is another term used in real estate deals where buying subject to means the home is subject to an existing mortgage that the seller is not going to pay off. The buyer has taken over the payments of the unpaid balance, and then is calculated part of the purchase price. for example, a seller took out a mortgage for 200,000. They had paid 150 of it before they decided to sell, and new buyers would then make payments on the existing 50,000 until paid off. If the buyer does not pay off the mortgage, it goes default and affects the seller's credit rating, which is a disadvantage. Under the subject to arrangement, buyer continues to make payments and the seller's mortgage to the seller's mortgage company. However, there's no official agreement in place with the lender. The buyer has no legal obligation to make the payments. Should the buyer fail to repay the loan, the home could be lost in foreclosure. However, this would be an original mortgage. It would still be in the original mortgagee's name. The arrangement poses risks for the buyer if the lender requires a full loan payoff, due on sale clause, or if the seller goes into bankruptcy. Oftentimes people will file a document with the recorder called a notice of request of default on an existing loan for this kind of transaction, so that the lender is put on notice that if the buyer or anybody else fails to make payment, that person who requested the notice of default gets a notice that it's going to foreclosure. Interspousal transfers or interspousal transfer deeds, where property is transferred between spouses without monetary exchange. Now, in a lot of these deeds, you just make up a form and you put the big letters on the top. Oh, this is an interspousal transfer deed. Well, you could also use a grant deed with the same terms or a quitclaim deed. Oftentimes, these kinds of deeds will include things like divorce decree, agreements, property settlement agreements, and different things. And it's basically reserved for between spouses transferring assets. Some examples would be husband and wife transferring property into community property, or community property with right of survivorship, transfer on death deeds, joint tenancy, two-step operation, tenants in common, deed after divorce. I need to mention something about community property. You can have community properties, a significant issue in property law, where any property acquired between husband and wife during marriage, except for gifts and inheritance, is assumed to be community property, and then it has that ownership. So if a husband and wife takes title as husband and wife community property and one of them dies, well, how's the other spouse supposed to get the property? In that case, you have to file a spousal property petition. If you were to have the deed recorded as community property with right of survivorship, then the surviving spouse would only have to file an affidavit of death of community property ownership with a certified copy of death certificate, and then the survivor would get the property. And then the joint tenancy, if there's two, or say there's three joint tenants on the title, and one of them dies, then the other two surviving joint tenants get their interest. There's no probate on joint tenancy. There's some tax problems. You don't get a step up in basis properly, like you would with community property. And there's a misconception. I've seen people put it in their will and their trust that this property is going to transfer under these terms. If you look at the title, it says joint tenancy, and the trust or the will has nothing to say about it. This joint tenancy with right of survivorship governs, and every court would ignore a will and trust that said the contrary. So this is an example of an interspousal transfer deed with explanatory sections. We have, is it exempt? I think this one's 11930, the Revenue and Taxation Code 11930. So you don't have documentary transfer tax. And if it's to a person who's going to live in the house, then the $75 fee is not taxed or assessed. And it says how the transfer came about, and the grantor details, legal description, and of course you have the notary requirement also. Oh, now we're getting to husband and wife community property. I thought we passed it. What is CP? Community property. Husband and wife community property reviews a legal framework in the United States, such as California, where property acquired during marriage is considered jointly owned by both parties. Only about 7 states in the United States have community property. California is one of them. Title could be held as husband and wife as community property. That's not the best way. Each spouse is an equal share of the community property, regardless of who acquired or holds title to the assets. In the states where the assets that accumulated during marriage are typically shared equally between the spouses in case of death or divorce. The concept aims to recognize the contributions of both spouses to the marital estate and promote equitable distribution of property within the marriage. Yeah. Community property with right of survivorship. Way to hold title. Community property right of survivorship is a specialized form of property ownership available in community property states such as California and Wisconsin. This arrangement, a married couple holds real property or other assets with the added feature of right of survivorship. What's that mean? No probate. Under community property laws, both spouses share equal ownership and management rights over the property acquired during their marriage. With the right of survivorship, one spouse passes away, the surviving spouse almost automatically inherits the deceased spouse share without the need of probate. This means a property passes seamlessly to the surviving spouse outside the new probate, providing straightforward cost way to transfer ownership. Community property right of survivorship ensures the surviving spouse retains full ownership and control after the death of the first spouse, simplifying the transfer of assets and avoiding the potential complications with probate. So after one spouse dies, you file an affidavit of community property owner with a certified copy of the death certificate, and it clears the decedent's name, and the other spouse now would own the property in severalty by themselves. What is joint tenancy? Joint tenancy is a form of property ownership where 2 or more individuals, known as joint tenancies, collectively hold equal shares. Joint tenancy is an undivided interest in the whole property. Each can share the right to use the property. Crucial characteristic is the right of survivorship. When one croaks, the other ones automatically own their share. It does not go to probate. It's not controlled by your will, not controlled by your trust. And if there are several owners, say there's 5 owners, and then one person changes and sells their interest, and that new person comes in on the 5 owners, the new owner comes in as a tenant in common, which means that they can transfer their property by will and trust. There's a problem with joint tenancy for the survivors is for property tax purpose, not property, for income tax purposes, only, husband and wife, let's say they own joint tenancy, only half the property gets a step up in tax basis when one joint tenant dies, where if the couple held the property in community property with right of survivorship, both halves of the property would get a step up in tax cost basis, so the surviving spouse could sell the property the next day and not have to report any capital gains. Okay. What are tenants in common? So where two or more people, it's called concurrent ownership, own an undivided interest in property. Let me go back to joint tenants for a second. They call it unity of title, and you have to know this. In order for joint tenancy to work, there's a phrase called time, title, interest, and possession, where everybody has to go on at the same time. They have to own equal percentage. And they have to own equal percentages, and time, title, interest, and possession. They all have an equal right to access all the property. And so we learn the phrase TTIP, time, title, interest, and possession. If you, they have to own equal percentages. So if you said one person owned 80%, one person owned 20% in joint tenancy, that would fail the four unities, and the court would likely treat that as tenants in common. Now, tenants in common, another form of concurrent ownership, more than one person on the title at the same time. Tenants in common is a form of ownership where two or more individuals, known as tenant in common. Unlike joint tenancy, each tenant in common can have different ownership share percentages, which may or may not be equal. For example, one has 50, the other has, two others have 25%. In this arrangement, each tenant in common has a legal right to use and enjoy the property regardless of their ownership percentage. However, their ownership interests are separate, and they can transfer their shares to someone else without the consent of the others. Critical distinction in tenants in common is that there's no right of survivorship. If one tenant in common passes away, their share of the property passes on to their heirs and beneficiaries according to their will or probate, rather than going to the surviving tenants. This can result in multiple owners with varying shares and the potential for more complex ownership arrangements. Deed after divorce. Transfer deed, usually you refer to the divorce decree and the courts telling the individuals who's going to get the property. Transferring property to or from a living trust. A trust transfer deed or a grant deed to a trust, not a trust deed. That one I can't have. It's not a trust deed, cannot be a trust deed. For various reasons, that means something has to do with a loan or an encumbrance. It's a legal instrument used to transfer real estate ownership from an individual to somebody's trust. In the process, the property grantor executes a deed conveying the property title from the individual names to the name of the trust, and in the names of their own names as trustees, the property becomes part of the trust asset for the legal owner. Primary purpose of a trust transfer deed is to facilitate estate planning and asset management. Placing the property in a revocable trust allows for seamless transfer of ownership beneficiaries upon the grantor's death, avoiding probate proceedings. And additionally, the trust terms can dictate how the property is managed and distributed during the grantor's lifetime. After their passing, ensures that their wishes are carried out effectively. A pour-over will is not a deed, but a pour-over will is a legal document to complement a revocable trust to tell the executor that the assets should be transferred or poured over into the trust. When it comes to real estate, the person owns real property not held in the trust will direct it to be transferred into the trust ownership. It simplifies the probate proceeding, maintaining continuity of the trust terms, but you still have to file in probate to get the judge to say, okay, transfer it into the trust. There's another thing too that might impact that here, and that's called a Hegstad petition. So we'll think about that. This is an idea where instead of distributing assets out directly to beneficiaries, in this example, 3 beneficiaries, you distribute assets out in 3 subtrusts, 1 trust for each beneficiary's name, to help protect their assets in the future. Transfer of title to business ownership, basically from an individual to a company or LLC. You basically transfer it from the individual using the type of deed you've selected, grant deed, quitclaim deed, whatever, and then the grantee is the LLC, and it might, some real estate investors use LLCs for liability protection. I think it's overrated. I think property insurance does a lot to eliminate that need. But they are used, and you have to be careful transferring ownerships of the LLC membership interest. If over 50% of the members of the LLC change, you have to file a Schedule B within a California FDB form 568, telling that property or the owners change so that they can reassess your property, even though it's not changing title in the LLC itself. Transfer to a corporation, deeding from an individual. To simplify this, there's adverse real estate and income tax consequences, and I advise never to put real estate in the name of a corporation, because in the future, when you take the property out of the trust, even if you want to put it in your own name, that's going to require a capital gain from the corporation to you at the fair market value. It also has an adverse effect on step-up basis. And when you take property out of a corporation to an individual, you get assessed for property tax. So a corporation and real property is the worst of all worlds. And I run into them every so often, and they go, well, we really messed up. How do we get out of it? Easy. You just pay all kinds of tax. Transferring title to a partnership, it's not done that much. Most people are using limited liability companies, although you can do it. A partnership is essentially a limited liability company with unlimited liability for all of the partners. Affidavits of death. Okay. So, what happens on the death of a tenant in common? On the death of a tenant in common, their ownership shares will pass according to their will, or if there's no will, we'll go through probate. As tenants in common, each owner owns a separate, distinct, and transfer ownership, means they can sell, gift, or use estate planning. When a tenant in common passes away, their share does not automatically transfer to the other owners like a joint tenancy with the right of survivorship. Instead, it becomes part of the decedent's estate, and the executor or administrator of the decedent's estate is responsible for handling the distribution and going to probate. In some cases, deceased tenant in common may leave their share to a specific beneficiary or as a devise in their will. Death of trustee or change of trustee. This form is affidavit of death of, or affidavit of death of transfer of trustee. Do you have an example of this? Yeah, we'll see that in a second. So you've got two trustees on there. One of them dies. You have to file this affidavit of death of change of trustees, include the death certificate of the deceased trustee, and show that the trust has not been amended or revoked, and that the existing remaining trustee stays on title. Upon the death of a trustee, the successor trustee, if one was appointed in the trust document, assumes the trustee's responsibilities and duties. The successor trustee is the individual or entity designed to take over the trustee in the event of the current trustee's death or incapacity. If there's no designated successor trustee, the trust document typically outlines the process for appointing a trustee, which may involve the beneficiaries of trust coming together to select another trustee, or it may require court intervention to appoint a new trustee. During the transaction, assets of the trust remain protected and under the control of the trust. The new trustee takes on the fiduciary duties and responsibilities, managing the trust according to its terms and distributing the assets according to the beneficiary specified in the trust document. Okay, here's an affidavit of death of trustee of a document you can record. And we have the usual suspects: the Revenue and Taxation Code, Government Code 27388, assessor parcel number, who died, why, and when did they go on title originally. You cross-reference legal description and notary. Okay. Death of a joint tenant. On the death of a joint tenant, the surviving joint tenant automatically becomes the sole owner of the property, assuming there's two. This is known as the right of survivorship, a unique feature of joint tenancy. When one joint tenant passes away, their ownership shares in the property. It is absorbed into the surviving joint tenants without going through probate. As a result, the right of survivorship, the deceased joint tenant's interest, does not pass through their heirs or beneficiaries through a will, or trust, or through intestate succession. Instead, the property is immediately and entirely owned by the surviving joint tenant. It's important to note the right of survivorship applies only to joint tenancy and community property with right of survivorship. If the property is held in other ownership, such as tenants in common, the deceased owner interest will be distributed according to the will or state laws and may go through the probate process. Don't you just hate it when that happens? Here's an affidavit of death of joint tenant by a surviving spouse. Okay. Looks like a deed, but I would still put the exclusions, like we've talked about, in this area. And notarize, of course. Dissolution of a corporation. Okay, if corporation owns property, they still, okay, so I'll just tell you. I had one where I found 3 parcels. Like, my client's dad was a real estate developer, and I was looking through property records, and I found 3 parcels of property they didn't know they owned. One of the biggest parcels was owned by the dad's defunct corporation. And so in order to get property title back, looked up the codes and found out once a corporation starts to dissolve and distribute assets, it continues forever. No statute of limitations. So we had to elect a board of directors, and the directors elected officers, and then the officers transferred the title of the property out of the defunct corporation's name into the only beneficiaries. Quite a unique event. Death of a community property owner. On the death of a community property owner, property is typically affected by the right of survivorship. In community property states, California, Arizona, Texas, and others, property acquired during marriage is considered community property, jointly owned by other spouse. When one spouse dies, their share of community property is usually transferred to surviving spouse automatically without going to probate. Yeah, sometimes. The right of survivorship ensures the surviving spouse becomes the sole owner of the deceased spouse's share of community property. Property's title is updated to reflect the change of ownership, and the surviving spouse gains full control and ownership of the rights of the entire community property after the proper pounds of paper have been filed. However, if the deceased spouse had separate property, which includes assets before marriage, or through inheritance, gifts specifically designated for one spouse, their separate property will be handled according to their will or the state's laws of intestate succession. This may be subject to probate to transfer ownership to the designated beneficiaries. One thing that's very novel in California law, if one spouse owns property and they get a divorce, it's treated separately than if one spouse owns property and they die. So the title on how they're holding title on death governs the interpretation of the ownership title, but on divorce, it's more fluid. Okay, so back on this about community property. If you have community property, holding property is community property, husband and wife, and one dies, it's not with right of survivorship, so you have to file a spousal property petition in the probate court to get the transfer of the property to the survivor. If the property was held as community property with right of survivorship, you don't have to file anything in probate court. You file a death of a community property owner along with a death certificate and affidavit, and then the property, the right of survivorship law transfers to the surviving spouse. So this is an example of surviving spouse getting community property in Santa Clara. So it talks about where it was originally recorded, and they're married, okay. And how they're going to vest title. Okay. Now, what do we have here? Looks like a court paper. Spousal property petition. Oh boy. Spousal property petition is a legal process used in certain states to transfer real property, other property from deceased spouse to the surviving spouse without the need for probate. When a married person passes away, their estate may need to go through probate court supervision process, develop, date their will, and distribute assets. However, in a community property state and other jurisdictions that recognize spousal property petitions, the surviving spouse can use this streamlined procedure to control the property and the spouse's share of community property and other eligible assets. The surviving spouse files spousal property petition with the court along with necessary documentation declaration that the property qualifies for the spousal transfer. Once approved by the court, the surviving spouse obtains full ownership rights avoiding the time-consuming and costly probate process for eligible assets. This tool simplifies and expedites property transfers between spouses, providing straightforward means of securing ownership of property or assets without the need for probate proceedings, but you gotta file it in probate. So this is the form you file in court for the spousal property petition. Use a petitioner, all those little boxes, and file that. And after the judge rules, you own it. Okay, death of community property with right of survivorship. Oh, what do we have here? Oh, so death of community property with right of survivorship says, upon the death of community property right of survivorship owner, typically community property states with the features, secure surviving spouse automatically becomes the owner of the property. In community property states, the right of survivorship, both spouses, when one spouse is away, immediately transfers by right of survivorship. Surviving spouse gains control. It's essential to note that the right of survivorship applies only in community property with right of survivorship states. So, in this case, we have affidavit of a surviving spouse or registered domestic property, registered domestic partner, RDP. Phone property, they're married. Above, it's been more than 40 days. Respect the property has not been election. Property's not been disposed of in trust or the will. Here's the affidavit. Okay. Yeah, the only thing I don't see on here is should put the death certificate, but okay. And this is a jurat. It's not an acknowledgement. Affidavits are jurats. Don't mix them up, Mr. Crandell. Transfer on death deed, owner. Oh, upon the death of transferred on death deed, automatically transfers. On the owner's passing, beneficiary must present the owner's death certificate and file an affidavit or other required documents or appropriate account in the recorder's office to confirm the transfer of ownership. Once transfer is recorded, beneficiary becomes legal owner and all subject to all the goddamn personal debts of the decedent. Keeps things out of probate and affidavit of death of revocable transfer on death deed. So this is your example on how this little puppy looks. And that's a valid jurat with a proper notary. And we move right along. Are we done yet? This is unbelievably long talk. I sure hope everything's going well. So we have loan-related documents, which we're going to cover. And deed of trust. A deed of trust or trustee is a security interest on real estate transactions. Involves three parties: a borrower known as a trustor, the lender known as a beneficiary, and a neutral third-party entity called a trustee, usually a title company. The deed of trust serves as a lien against property, giving the lender the right to foreclose the property if the borrower defaults on a loan, unlike the mortgage, which involves two parties, the borrower and lender. It requires foreclosure. Deed of trust allows for non-judicial foreclosure proceedings through the trustee. Thus, the borrower fully repays the loan. Trustee reconveys the property back to the borrower, and deed of trust is satisfied. This document provides a secure, efficient method for lenders to protect while allowing the borrower access to financing for property purchases. Promissory note. It's IOU. And a promissory note is commonly referred to as a mortgage note, legally binding document, serves a written promise for the borrower to repay the real estate loan. Okay. It outlines the terms and conditions of loans, including loan amount, interest rate, repayment schedule, other relevant terms. Promissory note includes the borrower's commitment to make regular payments, specifying the amount and frequency of the payments. It also details the consequences of default, such as late fees, possible foreclosure, and note. It is separate from a mortgage or deed of trust, which provides the lender with a security interest or collateral for the loan. So the lender retains the original promissory note, IOU. It's not recorded as evidence of the debt, and the borrower receives a copy. This legal document protects the rights of both parties, ensures the terms of the loan are clear and enforceable throughout the term of the loan. And then there's a deed of trust, which is recorded against the property as a lien, so that if they default, then the trustee on the deed of trust can sell the property. Promissory note secured by deed of trust. Does that say it again? Promissory note. Now it's secured. Promissory note secured by deed of trust, a legal arrangement using real estate transactions to document a loan, a promissory note, written promise. Deed of trust is a separate legal document that does not recite the loan terms, provides the lender with a lien, and allowing them to foreclose and sell the property on the borrower's default of the loan without going through a judicial foreclosure. The combination of promissory note and the deed of trust allows the lender to protect their interest in the case of non-repayment, while providing the borrower access to financing. Such arrangements are commonly used in mortgage loan to provide clear and enforceable structure. Here, my friend, is a shortened version of a promissory note that refers to a deed of trust. In the 2008 Great Recession, they had a lot of times when they were trying to foreclose, and then the borrowers were saying, let us see the original note. And the lenders couldn't find it, so they had trouble foreclosing. But this is a sample note, certain payments, and usually there are a tremendous number of pages, and not just this little amount. And then deed of trust, assignment of rents. This gets recorded. You'll see our usual code sections over here. And this sticks on title showing that it is a lien. And then if anybody buys the property, this loan doesn't go away. It still travels with the property title. A carryback mortgage is also known as seller financing. Carries back a portion down payment. Carryback mortgage can be used to help buyers. I'm not sure. This looks like it might be a page 50, slide 56. Duplicate with some prior, but then there's a thing called a shared appreciation mortgage, where the note was written with special wording that the lender is going to share in the profits of the property appreciation in the future. So there's no limit to what you can write into a deed of trust and related mortgage loan instrument. Substitution of a trustee on a deed of trust. So in order to foreclose, they have identified a trustee. I had one where the trustee went out of business and we had to track him down to get another trustee because the loan was paid off and nobody filed a deed of reconveyance. So the lien was sitting there inappropriate. So this is a change of, maybe Chicago title was the trustee originally, and then they decided now, okay, Wells Fargo is going to be the trustee. And this is a kind of form that is recorded. Substitution of trustee, same form, no different. That's the full thing. Deed of full reconveyance. This one's important when you pay off your loan. So the note's been paid off and you still have this lien or cloud on title. It removes the lien on title that was created when the loan was taken out against the property, removes the pre-existing deed of trust, and serves as collateral that served that in the past as collateral for the bank or private lender funds. So here's a deed of full reconveyance, clearing the cloud on the title. Okay, now notice the default. When you, other states have mortgages, California does not. And the reason is that if you want to foreclose on a mortgage, you have to have a judicial foreclosure, go to court and get a court order. In states like California, where they have a note deed of trust system, you do not have to go to court. You have a private trustee who's going to sell the property for the benefit of the beneficiary, the lender, and any extra funds at the auction will be given to the original buyer, owner. And when a loan is not being paid, this notice of default is recorded against the property, or it's given to the borrower. And if you do not pay your loan, the lender issue notice of default will start the procedure to foreclose and related trustee sale. Any funds above the loan at the auction are given to the borrower. The full balance of the loan is now due, not just the monthly payment. So this is a summary of a notice of default, and it is not recorded. Okay, now we're going to have a notice of trustee sale. These are usually talked about. You're going to sell the property on the courthouse steps. Notice of the day and time when your property will be sold by auction to the highest bidder. The lender can bid the balance of their loan without putting in cash. All auctions are for cash sales only. And that's a misspelled word. Let's get that taken care of. Auctions, not actions. Let's not have any typos around here, huh? No way. Let's see. Good. Wonderful. Now, here's a notice of trustee sale, the whole form. Lots of poop. Self-canceling installment notes. This is another way to write a note. Self-canceling installment notes, a financial tool using estate planning, transfer assets to beneficiaries while minimizing estate tax. It involves the sale of an asset, typically real estate or a business, from one owner to the beneficiary using an installment note. No money down, sale to kid, no capital gains now. The note outlines the schedule of payments over time, and the grantor receives income from these payments. The unique feature of the self-canceling insurance note, self-canceling installment note, is contains a self-canceling clause, which means that the grantor passes away before the note's fully paid off. The remaining balance is canceled automatically, and the beneficiary becomes the full owner of the asset without any additional estate tax implication. By employing a skin, the grantor can significantly reduce taxable value of their estate, since only the present value of the installment payments are subject to estate tax. The potential for estate tax savings makes skins an attractive option for transferring assets to beneficiaries in a tax-efficient manner while also providing income to the grantor during their lifetime. It can also be used as a strings attached type of early estate distribution before the settler dies. However, estate planning is a complex matter, and it is essential to seek guidance from qualified amateurs to ensure that strategy aligns with individual circumstances and goals. You bet your bippy. Les pendens. Les pendens is a legal notice filed in the recorder's office to indicate a pending lawsuit involving a piece of real property. It serves to alert to potential buyers and creditors of the property's disputed status. It is to preserve claimants' rights during litigation. To remove it, parties must resolve the underlying dispute or request that the court cancel a lien if it was improperly used, or if the case is dismissed or settled. If a buyer acquires a property, it's a less pendants on the title. They just bought a lawsuit. When writing a less pendants to court against title, be extremely hyper technical and compliant with the law, because the person filing it can have liability for clouding the title unreasonably against the victim property. Abstract of judgment. This little puppy's fun to use. An abstract of judgment summarizes a court judgment. You owe me money, such as the amount owed by the debtor to the creditor when recorded with the county recorder's office. It creates a lien on the debtor's real property, affecting the property's title. It means that if the debtor sells or refinances, the creditor has a legal claim to receive payment from the proceeds or the new buyer. Someone might file an abstract of judgment to secure their right to payment after winning a lawsuit, ensuring they have recourse if the debtor attempts to sell. To remove the lien, the debtor usually needs to satisfy the judgment by paying the amount owed or negotiating with the creditor. Once the judgment is paid in full, another form called a satisfaction of judgment should be filed with the court and recorded with the county recorder, lifting the lien from the property's title. Wow. Are we having fun yet or what? My God. What's a mechanic's lien? California mechanics liens are filed by contractors, subcontractors, or suppliers who provided labor, material, services, construction on a piece of real property, even the roofing supplier, for example. It's used to ensure the payment for the work or materials when a property owner or general contractor fail to fulfill and pay their debts, obligations. The lien encumbers the property title, potentially making it difficult for the owner to sell and refinance due to the cloud on the title caused by the outstanding debt. The mechanic's lien can be removed by the property owner upon settling the amount owed with a claimant, or by the claimant releasing a lien after receipt. If the dispute is unresolved, the property owner can request the court action to determine the validity of the lien. Once the lien is settled, a release of mechanic's lien document is filed with a recorder to clear the title on that encumbrance. Miscellaneous government property tax sale deed. This is California property tax deed is where the property owner has for 5 years not paid the property taxes, and the property is seized by the county and sold at public auction to the highest bid to get their taxes. Tax defaulted property auctions list the properties for sale that are announced by the county and websites and local newspapers, and they're entertaining to participate in. If in California, when real estate is sold for non-payment of property taxes, the deed received is called a tax deed. This deed is issued to the winning bidder at the public auction conducted by the county tax collector or treasurer. The tax deed transfers ownership of the property to the successful bidder, who acquires a title free and clear of any existing lien or encumbrances, except for certain exceptions like federal liens. The previous owner has a dang statutory period of exemption during which they can repurchase the property by paying the delinquent taxes and other associated costs. So this is cancellation of tax deed to purchaser of defaulted property. Okay. Real estate property during a probate. Buyer offer in a probate. Original buyer's offer submitted to the probate judge for confirmation. This is when the executor administrator has limited authority under the Independent Administration of Estates Act. They get a property buyer and they bring the offer into the court, and anyone who attends or with the advertisement can overbid the existing contract. The next bid must be 5% plus $500 of the original buyer's offer. The judge will set the amount required for additional bids. The judge will also accept additional bids in the same manner as an auction until the highest bid available has been made at the confirmation hearing. This process brings more money to the probate estate for the benefit of the decedent's beneficiaries. The transfer deed is signed by the judge in favor of the new owner. Transfer in kind distribution at the end of a probate process. Beneficiaries agree that real property should not be sold, and one or more of the beneficiaries agree that they're going to get property instead of money. Any beneficiary in a probate can force the sale of property, which is a very strong right. The transfer deed is signed by the judge in favor of the new owners. So on the other hand, however, the objecting probate, any beneficiary, that's what I was saying, any probate beneficiary can force the sale of real property. Probate, the same rules do not apply to living trust. The right to partition of a jointly owned inherited house. Whether you've inherited vacant land or home with a sibling or other co-owners, the right to partition is absolute. Ordinarily, if a party seeking a partition, a sale of property to multiple owners, is shown to be a tenant in common or joint tenants, as the right is absolute and cannot be denied. The only indispensable requirement is that there's clear title to be shown, and in no event is a partition denied because it might result in a financial loss to the co-tenant. This means that all heirs do not have to agree on what to do with the property in order for it to be sold. If even one co-owner wants to sell the property, a partition action will force the sale of the inherited property. An experienced partition attorney can ensure the best outcome for the co-owners who disagree. Title insurance void on transfer to non-family third party. This is a warning when you're transferring title back and forth. There's title insurance for the last person who bought the property, and the title insurance is in their name. And so you start transferring the property, giving it to other people, and the title insurance ends up being void because they're not the original owner. So you might check to have an extension on title insurance on transferring property out of the original owner's name. Required tax withholding on the sale of real estate. This always goes over like a lead balloon. California franchise tax, or FTB form 593, facilitates tax collection in California for real estate transactions subject to backup withholding, almost anybody, and ensures non-exempt sellers have a portion of their proceeds absconded or withheld to cover taxes. The exact amount withheld varies on the transaction and value and the seller's tax status. So you might see $5,000 to $8,000 kept out of escrow given to the franchise tax board way early in the year, and the person entitled to it has to wait till the next year to file their taxes, get their money back without interest. FIRPTA, foreign investment of real property tax, backup withholding. I've done this on a sale of California property to an Italian priest, and 15% is withheld, given over to the IRS. And then it's the problem of the non-resident alien must file a tax return to get their money back, the seller can later file tax to potentially claim a refund. And if you don't do these withholdings, then either the title company or the seller are personally liable for non-compliance. Filing your first few deeds in person at the county recorder's office. Recording your first few deeds, transfer documents in person at the county recorder's office is preferred over mailing it because it ensures immediate processing, minimize risks of loss and delays in processing, and allows for learning and direct clarification of any issues, and provides a receipt as proof of submission. This in-person approach offers greater security, efficiency, and transparency in the deed transfer process for those beginning to file deeds. This is Alameda County has a documentary transfer tax, the normal $100.10 per 100,000, and then Oakland came about and created their own transfer tax of 1.5% of the value of the property. So we just saw one recently where the house sale was $800,000. Alameda County tax, $880,000, and the Oakland City transfer tax, just the transfer title, was $12,000. Most people are surprised to learn about the high transfer taxes in this location. And it's mostly in Alameda County, several cities. San Mateo County has got another one. And I'm not sure about the Southern California ones, but it seems outrageous. So in the appendix, we have included a lot of different forms for your use. And all these different ones will be there when we finally get around to it. I can't believe it. I'm almost done with this talk. And it took a lot longer than I anticipated. About 4:30 to 6:30. Dang, it looks like it might have taken 2 hours. Whoa. I hope you enjoyed it and are still awake. Good night from Washington, D.C.